Good morning, everybody. Welcome to another episode of Break the Cycle with DSD. I have a special guest here today, so I'm going to try to jump into my normal spiel real quick to get everything going. Welcome to Break the Cycle with DSD. I am your host, Duane. I am not a therapist, nor am I an attorney, but my guest today is. I'm an individual much like you who's been through a tough experience, and I've developed some tips and techniques that I use to help me through it that I share with you to help you get through this. Break the cycle of emotional abuse, minimize your mistakes, strengthen your relationship with your kids, and basically just get your life back. Remember, only a licensed professional therapist in a clinical environment can diagnose someone with a personality disorder. So be careful throwing around medical terms because it, like I always say, it hurts your credibility. And the last thing you need, especially when you're in court, is for people to start thinking that you don't have any credibility and what you're saying they can't believe. If you like what's going on here and you want to support it, you can become a channel member by surfing on over to youtube.com/dadsurvivingdivorce. Click the join button, and once you do, you get special badges, custom emojis, your name listed in credits, access to member-only events, and a special little section of the DSD Discord that would be just for you. If you want to get a text notification when the show goes live, you can text DSDLIVE to 844-598-0012. That's 844-598-0012, and that will get you added onto the SMS list so that you get a notification right to your phone with the link for the video. Like if you were on it today, you would have got a text notification, and you could have just clicked on it, and it would have went right to it, and you wouldn't miss a thing, except for those rare times that I forget to send it. And I am not going to have the phone lines open because you guys know that when we have special guests, the hour flies by. So on that, I'm just going to go ahead and introduce our guest today, which is Christine Gille from Gille Kaye Law Firm in Pasadena, California. Actually, she reached out on a comment maybe last week or so. So we've talked a few times, and I thought she had some great information that she could share with you guys and help you out. So she agreed to come on. So Christine, thanks for joining us. Thanks for joining us this morning.
Thank you so much. I'm sorry there's a lag.
Oh yeah, technology. It always seems to start out that way. So how are you doing today?
I'm doing really well, and I'm looking forward to talking about the questions you have for me today.
Yeah, I'm really glad to have you on. And just so everybody, well, I think I mentioned this, or maybe I didn't, but she's also in California. So probably one of the first people who actually is like, and I appreciate the fact that whenever I said, hey, we do the show at 6 a.m., you didn't go in the morning. So I appreciate that. So one of the things that we were talking about the other day, and the topics we were going to hit, well, the first thing is I wanted to ask you, and I never really looked into this because I didn't understand it when I was going through my case 9 years ago. But I wanted to ask you, what exactly in California, what are the best interest factors in California? So when the court is trying to determine that for child custody, what exactly are they looking at?
It's not simply laid out in the statutes, but it's health, safety, and welfare. What does that mean, of course? But what it does mean is that don't have your lawyer or yourself plead something like, this is best for me. Make sure when you're pleading, you're thinking about what's best for your child. And if they have health issues, if there are safety issues, or if there are happiness issues, which is what the welfare means in the statute, then those are the things you want to look at first.
Now, are all those, a lot of people are, even I have said this, that a lot of it is subjective and nuanced, I guess. Is that actually the case, or are there really ways to drill down to demonstrate the situation to where, like maybe joint custody or full custody is in the best interest of the child?
It's definitely a subjective test, and so it goes by proof, which is why your exhibits matter so much. Do you want more?
Well, and I wanted to, yeah, well, I mean, we're going to dive more into that too, but I mean, a follow-on question to that is, how do you develop the proof and how do you document what's going on to really communicate that to the court?
It's important to have, if you can, to have a history. Sometimes someone who's worked mostly outside the home, and when there's a breakup, now they want to spend more time at home. That's okay as long as you express it. But if you do have a history of when you went to the school, the parent-teacher nights, those kinds of things, shows the involvement. And when you're trying to go with health, do you know who your physician is for your child? Does the other side know, that sort of thing? So I'm being pretty general here, but it all is a matter of proof and to show that the child is every bit as safe and happy and healthy with you as he or she is with the other party, or maybe even more with you than with the other party, all depending on the facts.
Yeah, I know. The one thing I've noticed is let's see, how do I say this? The taking things out of context, right? I mean, it's like somebody will be involved and then a toxic type person will, because you didn't do it last Tuesday, well, you never do. They talk in absolutes and they completely tie one specific incident to mean to try to say the whole thing. And how would you recommend somebody deal with that whenever they're basically being misrepresented, maybe even lied about in court documents or in court proceedings?
And that is very common. And it's something that needs to be fought, but not with emotion, which is hard when you're just being hit with this. So you have to end up looking at each fact and then either disproving it, because it is their burden to prove that. So once you're able to disprove, then the ball bounces back to them, and they have to show that you're wrong. So the more accurate your proof is, the better you'll be at fighting that sort of thing. And we could go into some examples.
Well, I wanted to ask you on that too, because it seems as though your or like, let's say if I was your client, it seems like my presentation, how I hold myself and how I come across in court plays maybe more of a role than it should, right? So if I come in disheveled, or if I come in irritated, if I come in glaring at the ex, all those little nuances, do those play a factor? Because it seems like from what I've seen, they do.
Absolutely. If I'm sitting in court and I'm waiting for my case, and there's someone up with his lawyer or without, or her lawyer, and they're interrupting the other side, yelling, he's a liar, she's a liar, pounding the desk. I don't usually see that, but I do see telling the judge that he or she is wrong.
Oh, dear God.
I've seen try not to either be angry or whine. The court is supposed to be a place for dispassionate reasoning, which is really hard when you're being attacked. So you almost have to step outside yourself.
But I think, let me ask you this. So if you are being attacked, and this is kind of actually, it's interesting you say that, because the approach I had when we ended up in our initial hearing, and my attorney, sat next to the other attorney, and during the first break comes out in a panic with a piece of paper, and he's like, "Oh my God, they just gave me this," the attorney was like, "Oh, did you see this?" And it had all kinds of horrible stuff. And he flipped to the last page and he had it highlighted, and he's like, "I'm worried about this right here, where it says you're suicidal and you're homicidal." And I just looked at him. I'm like, "I ain't dead yet." You know, I mean, it's like, I haven't killed anybody and I'm still breathing. So that's bull. And he calmed down. And I just basically took it like, okay, I'm not even, I mean, that's a lie. That's bull. I just completely took it that way. And that day, let's see, we were at 80-20. I was asking for 50-50. And I think I walked out with like 35% or something. So it was kind of like nobody really won, but nobody really lost either. But I think that had I responded differently, or if I had kind of panicked or really freaked out, that it probably would have hurt my case. Would you agree with that?
I would absolutely agree. And if you know something's coming, it's better to tell your lawyer, but it's also good not to have a lawyer that panics, of course.
Right.
But you handled it well. And of course, that's probably why you have this show, Duane, because you have that certain ability to cut to it. But at any rate, if surprise things happen, if all else fails, you can ask for continuance to bring proof. But usually those surprise things, if they're not kept out of court for being untimely, which happens, are something that you are allowed because of our principle in the United States, at least, of due process. You're able to see that and you're able to provide counter argument to that. So you want to, and even if it's horrible. I had a client once who is ADHD and so was taking what for most people would be speed, but it was legal for him. But his great ex-wife said that he was on speed and wanted him monitored around the kids. So we had to put on the testimony, but you have to calm down enough so that you can be able to see through that nonsense and get to the real facts so the judge can see it.
Yeah, one of the things I've noticed is that if you can stay calm and persevere through it, and although it's completely unfair, right? I mean, like in the situation you just explained, to have that taken, like I was just talking about before, taken out of context, and now you have to defend yourself, and now you have to spend all the extra money and to do it. I mean, that right there is enough to drive you, to push you over the edge sometimes. But if you can just calm down, things generally come to like rise. The truth comes out, right? I mean, you just basically said that. And I guess so. My follow-on question on that, and I had someone ask me this the other day, is why does it seem like the burden of proof falls on the target of these things? I mean, is it just a family court thing? Or, I mean, because everywhere else it's like, you're innocent until proven guilty, unless it's in family court. And then we'll just err on the side of caution and we'll limit your visitation, or we'll give you supervised visit. We'll do all these different things until you prove a negative, basically.
Yeah, and you want to try to make it so it's not proving a negative, but that you're proving a positive, the alternative to whatever they're saying. It's not that the burden falls on the so-called guilty. What it is that they make an allegation, then you disprove that, and then the ball is back in their court. Remember, in California, we don't have juries. So essentially, you're saying all of this to the judge. And so it does go back and forth, back and forth. But if there is something that, for example, if the ex is saying that you're a drug addict, to keep with that example,
right,
they have to actually have some proof. So you freaking out and just sort of saying, I didn't do it, that isn't your proof. And should you in some sort of universe not have to prove that they should bring proof? Yes. But because of our back and forth that we get to in court, if it's something that hasn't been briefed, then in other words, put into your declarations with evidence, then you end up with a little bit more of a free-for-all and you're feeling a little out of control. So it's usually better to attack all of that in advance.
Yeah. That's a great point. I had a question that I wanted to bring up. It's from Win Forward, and it says, could you ask what to include in a write-up to explain a relationship and involvement in your child's life? So you'd mentioned that earlier, and that's a really great question. How would you specifically do that to actually demonstrate that?
So Win Forward, there are quite a few ways to do that. But first of all, is Win Forward in California, or is this
no, I don't. I think they might be in New Jersey. So I know,
Okay.
and I guess that's one thing we probably should say. I mean, you practice law in the state of California, so the information you're going to give is going to be specific to you, to your area. But I think there's a lot of takeaways that people could use pretty much anywhere on the planet that would be helpful.
Okay, I'll keep it general then, but specifically if you're writing up a declaration, or in some jurisdictions it's called an affidavit before the hearing. And this, if you are the filing party, it's going to be a little bit different than if you are the responding party. But you want to write your affidavit or declaration in a way that divides it by subject, not just by date, would be the way I like to write them, so that you have involvement with the children. And then you'll have a short paragraph, and then if in your jurisdiction you're allowed to actually attach exhibits at that stage, then I like to have the exhibit there. And so your very short declaration could end up being a 2-inch document with all of the exhibits attached. So what you're really doing is, and I'm getting too long, aren't I, Duane?
No, you're fine. I was just gonna, since you paused, I was gonna ask a question. Like when I did mine, my attorney had said, the declaration needs to be less than 10 pages. And I was kind of fixated on that, but I didn't think about that I could have, so 10 pages and maybe the exhibits being, photographs or report or, different things. That's fully, acceptable. That's okay.
Well, in this jurisdiction, but I do believe because of my national context that some form of that is allowable in all jurisdictions, but absolutely. So if you say that that the children have that you've been the team dad, say, for a baseball or a softball league.
Oh, okay.
Then and then say, see exhibits, and then maybe you have, a picture or a certificate or proof that you've been the one taking the kids to the game or the ballet troupe or the chess meet, whatever it is. If you can get a little of that, and it shows what you want. And yes, it's a little more work to put all of this, but it turns that little short document, your 10-pager here in California, into a book of the life of the children. Oh, and before we forget, Duane, we want to make sure that your listeners know that you're focusing this on the children, not yourself. It's best interest of the child, not best interest of the parent. So every paragraph, write your draft, that's fine. Write it for your lawyer, write it for yourself, but then go through every paragraph and make sure it's about your child. So switch it around.
Right.
Susie enjoys being with me, and I know that because, as opposed to, it's my right as a mom or dad to have Susie 50% of the time.
Oh, I see. Yeah, that makes sense. I'm trying to remember how I don't think we necessarily got to that point. I always just said, and actually it's funny you say that because I hadn't thought about it, but my approach was the kids need both parents. I'm not saying that it needs, they need to be with me 100% and never see mom, but they need equal access to both parents. And that's kind of the way I approached it. Like even when I went through the custody evaluation, that was my thing. And even when I brought up issues with them, I was just like, well, I have these areas of concern. And I wish I would have known more, because I would have worded it differently, which I think would have probably maybe helped illustrate my point better. But I was just like, well, I'm concerned about the mom doesn't have any, there's no discipline in the house. I mean, there's no structure. She tends to, well, now I understand that a lot of it is the narcissistic, those type of issues that normally come with somebody who potentially could have a personality disorder, because mine was never diagnosed with anything. But I mean, the thing of being more friends with the kids and not a parental figure and all those kind of things. And ultimately, I mean, none of it was really, I guess it wasn't necessarily listened to. I mean, what came out of it was a 50-50 recommendation. So I was just blathering on there, but I was just, you said that and I just started like reminiscing and kind of reprocessing that. So.
Well, absolutely. And the hard part about this is you're not just talking about $1 million building you're selling. You're talking about your kids. I'm teasing there, but family law, sometimes people say, oh, we're only arguing about families. But families to us are more important than the $1 million deal.
Oh, the $1 million deal would be easier, because it's not, at the end of the day, if you lose the deal, you go home to your family, you go home to your kids, you take little Johnny or Susie to a movie. Well, back in the old days when we could do that. But yeah, I mean, I that's what I think is so tough about this is it's like, it's your entire life. It's everything that you've built for your entire life. And it's now somebody else on the bench is going to decide it. And it's super scary. It's terrifying.
And if you can't settle, then it is for the bench officer. That is your audience. And he or she may not ever have had kids. They may not know anything about family law, or they may be the wisest person on the planet. But I would say that if I were helping Duane in the past, if you're asking for 50-50, but you're slamming the other side, you're actually, and a lot of people do that.
Yeah.
But you're actually, the judge who sees, 100 of these a week is saying, well, he's not saying anything that makes me want to take the kids away from mom. So why is he so focused on slamming her? Of course, anybody who's listened to your show knows that there were a lot of other issues going on there.
Yeah.
But in an average case where it's not quite so toxic, doing a lot of spouse or other parent bashing, if what you really want is to prove that both are equally capable of being 50% parents, is sometimes a little bit of a waste when there's so much more that can be expressed about why the kids love it so much at your house, for example.
Oh, I see. You're actually wasting your time, right? I mean, you're taking that limited time you have to make your point, and you're focusing it on the negative where you could use it more effectively just to demonstrate to the court that, hey, this guy's, like in my situation, this guy's okay.
Yeah, it depends. Now, if you really have someone that should not be making medical decisions, for example, then you want to show why. But to do that in a case where you're just proving that, and I hate it when we go here, but anyway, that you're just as good a parent as the other one that has had more custody, then you want to show why the kids should be with you the 50% of the time. And sometimes your custody schedule works against you. So it's harder when you're an 80-20 dad or mom to have more examples. So then sometimes you need, you need a witness declaration sometimes. You need statements from, if your jurisdiction allows you to get statements from teachers. In LA County, where I am, the teachers have lawyered up pretty well, and you don't get too many statements out of them. But if you do, but say a coach or the ballet instructor, whatever, who knows you. So it pays to get involved with the kids, since you want to be involved with the kids, and then be able to prove it.
Well, it's interesting you bring that up, because I absolutely agree. And I would tell anybody, if you think things are going south, you need to engage yourselves in your kids' lives immediately. But take my situation where I was doing the stereotypical working dad, mom was stay-at-home mom, and she took the kids to the doctor for the most part. I mean, I did every once in a while, but it was more like she would get angry and, you need to do it. And all right, I'd take the day off from work, while she sat at home, and take the kids to the school or to the doctor, and then get yelled at if I did anything fun with them. That was fun. Anyways, I digress. But what happens, my point is, so you get into the situation, boom, you get blindsided, you're out of the house, and now you're going, oh crap, I've completely set myself up. How do you undo that? I mean, if you're the 80-20 person and you're going, oh no, if my whole life's been blown up, and I used to actually get to see my kids, at least when I came home from work and on the weekends and stuff, and now I don't. How do you fight that? I mean, if you weren't involved?
I usually say to people that they should front the parts of their cases that they see as negatives, because if you can explain that in the past you had that you were working full time and that mom was home. I'm using your example. It can also be reverse gender, of course.
Right.
But that now you have rearranged your life. So for example, I think you said you had a 2-2-5, what I call a 2-2-5 custody arrangement, where you had maybe Monday, Tuesday, she had Wednesday, Thursday, and then you traded off every other weekend. So you ended up with 5 in a row every other weekend.
Yep.
Yeah. Right.
And I was the Wednesday, Thursday. She was the Monday, Tuesday. But yeah, I had that.
One reason that's so good for people who have had less time in the past is because you can say, I have now rearranged my work schedule so that I have more time on Wednesdays and Thursdays. So I want to specifically take my daughter to, pick one, and I want to take my son to pick the other. And I will be going on the weekends to the tournaments or whatever, even on my non-weekends. And so I'm very eager to be able to do that, whereas I wasn't doing that before. And oh, by the way, and this is for child support, I'm no longer working 80 hours a week because I want time with my children. So therefore I'm making less, and I can prove it. But that gets to another topic.
Actually, the fact you brought that up, I mean, I was trying to figure out how, because that technically wasn't the topic we were going to talk about, but does that actually work? Because I hear so many people who get wages imputed, and that's one of those things that scared the crap out of me. I'm like, oh my God, if I lose my job, I don't want to say numbers, but we'll just say round numbers just because the math is easy. We'll say 100,000, and because I was working like a dog, and let's say, whatever, I can't do that anymore, or because of the stress, I lower it down. But I hear so many stories that the courts say, tough, you made 100, you're going to continue to make 100. And I don't care that you now are only making 50 or you're on unemployment or whatever. We're just going to tack it on to the end. How successful can you be in those situations to get that adjusted?
It's a pretty narrow area, and you have to be very careful with doing things that would reduce you down below full time. So in California, so you'd have to check your jurisdiction,
right,
for other people. In California, you're not forced to work more than 40 hours a week unless your industry works more than 40 hours a week. So 40 hours a week in law would be part-time. But that's the way it is. So if you were working 3 jobs, but that means that you can't see the children, so you want to go back to just your primary job plus maybe one side gig, that is something that is, when sold properly, always acceptable in California. as long as your industry is not something where suddenly you're hurting your ability to maintain your job.
Oh, I see what you're saying. So like if you were in the film business or something, I'm just pulling this, or, you know, and the
Mhm.
expectation is when you're on, and when you're off. And, you know, you couldn't do that. So, but I guess the main thing what you're saying on that is you have to be really careful how it comes across, right? Because if I was your client and I came into you and I said, you know what, I just can't do this anymore. I quit my high paying job and now I'm working as a barista in Starbucks and I went from 100,000 to 24,000. You'd probably be looking at me like, oh my God, you did what?
Yeah.
Now,
Yeah, you cannot do that sort of thing. There's specific, it's
criteria.
in case law. Well, yes,
Yeah.
earning capacity, and I did a little video on earning capacity, as a matter of fact, recently. You cannot go from something you're fully trained at to sipping Mai Tais on the beach in Hawaii and call it a day. You must uh, continue with your responsibility to support your children. That also works in reverse. Once you've got 50% of the time, there isn't a reason for the other spouse to sit home and eat bonbons either. Not that people usually do that, but that's what we say. So
Yeah.
you actually, when you free up time for them, give them more of an opportunity to, and perhaps they need training, but at any rate, to contribute more financially to the other side. I know that wasn't our topic,
No,
but
but I actually, and I have a follow on that too, if you don't mind,
no
is,
problem.
I know I had a conversation with the Department of Child Support Services when my second child fell off. And one of the things that they said, because I'm a sarcastic person and I like to joke around and make people laugh, and that's kind of what I was doing with the person on the phone. And they were, I mean, it was a good conversation. And I made a comment about um, asking about when how the process with the next child dropping off, and I jokingly said, yeah, I've been paying for her, she doesn't work or anything, and the person was like, well, she needs to get a job, and I'm like, yeah, I know, right? And she's like, no. She needs to get a job. We'll impute her wages. Just say the word and we'll start that process. And I'm like, wait a minute, what? And
Mm.
and I didn't do it, right? I mean, because I've been burned by the system. I swear to God, sometimes it felt like the law says this is the way it is. And then you flip it around. But, see page 2, and it was a picture of me, and it said, if it's this guy, don't do it. So, but is that true? I mean, would I have been able to impute her wages and lower support and stuff? Because I was still paying at 50-50 custody. I was still paying her. I mean, I was paying her enough to have a house, a car payment, feed everybody. And, I mean, she was basically retired on me until that child dropped off.
Well, you were.
It depends.
No, it does. It does depend, and if it was a long-term marriage, over
Which it
10
was.
years, California, okay. So there's a certain level of support for spousal support in this state um, that goes on, and then we have Gavron warnings. We have lots of things that make people go back to work, but in California and in most states, both parents are responsible to support the child. Now, that isn't something that the state government does because they care about kids. It's because they want people off of welfare. So
All right.
it is, yeah, but so it's a little bit more cold-blooded than the way it sounds. But nonetheless, both sides must support. And so the formerly non-supporting parent needs to step up. And however, don't expect the court to, just like in Duane's situation, don't expect the court to do that for you without asking. So back to Win Forward's question, if I might, how do I lay it out?
Yeah.
I always put, if it's an initial, we call them requests for orders, but it might be in order to show cause or emotion, whatever you call it in your jurisdiction. But in our initial requests, if it's for custody and support, that's exactly how you should put it. Don't get cold-blooded and put money on top and then the kids second, because then you'll get, if you do have a toxic ex, they'll say, see, they only care about the money. So this is sort of a mind game. And I just put the kids first. Just saying that that's what I think helps you. But in a separate section, then you start talking about the money. And if you have to reduce hours, fine. Most people don't do that right at the beginning, because you can't go to your employers and say, I quit. But on the other hand, you do say, you give your reasoning why 50% is better for the children, and therefore why you should be working only the amount of hours. It has to be full-time if you've always worked full-time, but only the amount of hours that helps you be with the kids more. And the fact that your ex is trained in a certain skill or would need some brush-up skills, all of that can go within the 10 pages, as long as you're organized and as long as you're concise and as long as you add the exhibits.
Well, I think and you make a great point there, because I mean, and I think even having the idea of a limit, then you have to be more focused and have hard-hitting points. You can't be all flowery and take everyone on a big, long journey. You just need to be really focused on, this is the issue, here are the facts, and just nail it. I mean, and I think that's great advice, because I mean, even if you're representing yourself, I mean, you need to understand this stuff so that you don't, because if I didn't know that and I put in a 75-page document, the Duane memoirs, nobody's going to read it. I mean, it needs to be something to where the court, I'm assuming that the judge or whoever, let me ask you this, does the judges actually read this, or do they have people read it for them? Or is that a bad question? Should I not ask that?
No. No, you should ask it, because it affects your strategy. Absolutely. You can take 3 weeks to write something, and on a busy day when the judge has maybe 20 to 25 cases, they're going to spend 10 minutes reading each one. So all of your nuances are lost. And so you really have to get to the point. So when I say add maybe a paragraph on something that happens, and then maybe a little quote, and then it says, see exhibit, in my jurisdiction, see exhibit A, or 1 or 2, whatever it works. But at any rate, they may not actually get to your exhibits, but the exhibits are there to support that quote, so that you shift the burden back to the other side. So my point being that if the judge is only going to take 10 minutes to read all of this careful material, think about even page layout. So I use subheadings, so that if the judge wants to know about your involvement, it's child involvement. Next one, the judge wants to know about why you should have Wednesdays and Thursdays. Then you make a subheading of that. So if all the court has time to do is look at your subheadings, then that's what they do. And if they want to read a little bit more, well, wait a minute, something's gotten, you've hit a chord in their minds. They'll read that section and maybe gloss over the rest. So it's not like a novel. They're not reading it from beginning to end and enjoying it. They're trying to get to the point so they can see why your case is different than the guy before you and the gal after you.
So let me ask you this, because, and I think I love that. I mean, that makes a lot of sense. But if a person has concerns with the other spouse or the other parent, how would you document that? Right. I mean, would you recommend that I even bring up anything that because here's the problem I think about it. It's like, for the most part, there's nothing too egregious in my situation. I mean, yes, I think that my ex has some serious problems, and I think they're causing issues with the kids, but they're so nuanced that it's not significant. I mean, I remember I would talk to my kids' therapist, and they would say, "Well, you guys are both good parents," and I'm like, "Well, what do you consider a good parent?" And it's like, "Well, your ex isn't putting cigarettes out on the children," and I'm like, "Okay, well then she's mother of the year." But I mean, the reality is if she was doing that, then it would make sense to put that in because that's a serious issue. But would I have been better served? And I don't think in response, I think I did throw some spears over at her way. Should I have would I have been better off just basically focusing entirely on me and the kids and not anything to do with the ex? Would that have been a better strategy?
Not necessarily. If communications are a problem, I usually have a section about poor communication.
Right.
Because uh, just because you have poor communications doesn't mean that you shouldn't be a 50-50 parent. So I would front that, as I've said, front the bad things. I think it's important to front things like communications. I think if there are lies and misstatements, and you're the responding party, I definitely have a section for that to show. I don't usually use the word lie because that's considered a personal attack, which in California we're not supposed to do.
Okay.
So I would say that these are all nuances. I'm sorry. I get a little nerdy at 6:30 in the morning. But nonetheless, I think in California, credibility is another one. Always important that when somebody is misstating, that they are specifically misstating to the court, in other words, lying to the court. If you have direct proof of that, it is really important actually to devote a little section to that. So you have kids, how great the kids are up on top. Maybe then you get to the credibility issues. Sometimes I put those after support. Each case is a little different. But if it's going to be where one side is attacking the other, there's an old maxim in law that says that if you do not respond to an attack, that you are accepting it as true. So you definitely don't want to ignore it. You definitely want to go there. You just don't want to put your entire 10 pages devoted to about what a jerk she is or he is, because then it looks more like you may be the one with the personality disorder.
Exactly. I love that point. So let me ask you this, because I often tell people I have a technique that I call hybrid no contact. And the whole premise behind it is whenever you get the email from your ex, that the 7-page email that outlines why you're such a scumbag and a horrible person and why you're the worst parent ever for little Timmy, that you ignore everything in that, all the accusations, all the hate, all the discontent. You find whatever the question was. So like in that 7-page document, if it was when is little Timmy's soccer practice, that's what you would answer. You would say, dear Pumpkin, Timmy's soccer practice is on Tuesday at 3:00 at field 7. Duane, and to ignore everything else. And some people get really freaked out thinking, well, if I don't respond to everything, then everyone's going to believe it. Now, in those correspondence, I'm okay, right?
What you're doing is actually great. There's an author, and he's also a lawyer, and he also is a shrink. He's like a
Billy Eddy,
triple
right?
threat. Bill Eddy.
Yeah.
And he writes a series of books. He's got a new one out, but it's all on this BIF, brief, informative, friendly, and factual. And I recommend those books, frankly, to my high conflict clients. And some of them hate having to read a book because they think they are doing it right. And they respond to the full 7-page email with an 8-page response. And those cases, if you find yourself in that situation, you want to stop. And I really, really would recommend reading one of Bill Eddy's, and there are other authors. And what Duane is describing that's so important is that you can add fuel to that fire, or you can just stop the fighting. Now, the interesting thing too, and I never let a good deed go unreported in these declarations. So if I'm learning parenting skills of a new teenager, for example, or if I'm learning how to communicate better, if I have a section in my declaration that says poor communications, then you could actually give an example of that. This is what we were doing in the past. This is what I'm trying to guide us toward. I've recommended to my ex-spouse that he or she also read this book. I'm reading it. I'm learning a lot about it. And the court thinks, oh, this person has the presence of mind to realize that you don't keep pounding yourself in the head. It doesn't get any better. So you end up, I put the books in, the parenting books or the communications books right into my declaration. It shows that you're growing in this life that you're going through.
I had a caller the other day who called in and was being accused of all kinds of stuff, drugs and whatever. And proactively, they went and got drug tested, and then went and did some classes and everything. And I'm like, dude, you're spot on. And it's so easy for people to get angry and say, well, I shouldn't have to do that. That's not true. But you got to really understand the fight you're in and be strategic, right? Yeah, you may be morally right, but if you don't do the right things, you're not presenting your best foot forward, so to speak.
Absolutely. It's not that, sure, it chafes a little bit that you're having to prove that you're the good person, or that both of you are good people. However, remembering that you broke up for a reason, and distrust is part of that. Trust is earned. And I have to say that a lot to people, because once trust is broken, and I don't just mean with an affair, but whatever broke the relationship up. And yours was a marriage, but over 50% of the relationships in California are non-marital. And sometimes they're relatively short. Wow. And people, it's so sometimes those short relationships have the most blow-ups because they really haven't learned what the other person's like at breakfast the next morning very well. But at any rate, what you're looking for is trying to convince a judge. So if you have to say, she has persistently said that I am a drug addict or an alcoholic, so I am bringing you proof that I am not that. Now, if this were a criminal court, it is not, so the defendant doesn't get up on the stand usually, almost never. But if the lawyer for that defendant can show, and it's in law school, they called it some other dude did it. So if you can prove that somebody else was there and did the crime, that proves that you didn't do it. So now back to family law. If you're having to prove a few things for the benefit of getting your children, and since this is a custody program and not a support program, then just do it, and do it with joy. It's all, I mean, you either resent it so badly you don't defend yourself properly, or you do it in a way that helps your case and keeps the cost down, really, because the cost of that fellow's what was it, drugs or alcohol test and training was a lot cheaper than lawyers. And sometimes the lawyers don't always say what you want them to say because they don't totally agree with your case. It's nice when you're in lockstep, which means you need to train your lawyer on what the facts are. But yes, doing the low cost but absolutely important steps to keep you out of. Duane, you said that you had a custody evaluation. I've heard you talk about it before
Yeah.
on your show.
Yeah.
Those things are hugely expensive,
Yes.
and
And mine was
and
cheap compared to what they normally cost. And it was
yeah,
still
some
like
of
$5,000 or $8,000. It was a lot of money.
yeah, they're really expensive, and they can be much more. And if you've already proven that you're not a drug addict, for example, then you don't end up having to pay some professional to prove that you're not a drug addict. So I love those self-help, not self-help in calling the person names or any of that, but proving your side of the case is always a good idea. And frankly, that half asleep judge that's drinking coffee and reading through 25 of these either at night before he goes home or in the morning before court, something like that really stands out.
That's it's amazing because it's so nuanced. And one of the things we didn't mention, but I just want to throw out there, I think this is why it's important to have a local attorney who understands, because I was going to ask you this. I would imagine that if you know that we have Judge Smith and you've been in front of Judge Smith, 17 times in the last year, and you know what they're looking for, that document that we're going to craft is going to be crafted for him. And maybe, Judge Jane or whatever, who completely has a different priority, it would be crafted different for that person. Am I right on that?
I think so. Weirdly, the judges do change. So sometimes you have to craft them for every judge and not just for a
Right.
specific judge. But I will say that although a lot of us lawyers have a fairly healthy self-regard, as in there's a lot of narcissists who are lawyers too,
Yeah.
and judges. But nonetheless, there usually in family law is not going to be someone that you should hire that's 200 miles away that's going to be better than a good, experienced local lawyer who you don't have to pay to drive down the freeway, who
Yeah.
knows the judges and who knows the other professionals in your area, so that if there are going to be side deals or settlement conferences, that they already know one another. So yes, I agree with that 100%, Duane, that you shouldn't get the pro from Dover that lives 3 counties away.
I did that. And what I noticed with my initial attorney, they were super expensive because it was in a more expensive area. And my ex's attorney would not answer the phone calls, wouldn't answer emails, completely ignored him. And nothing was happening. I mean, it was just like we were completely in a stalemate. He ultimately got sick. I picked somebody local in, like 3 blocks away from the other attorney. And it was like night and day. It's like, then then the paralegals would communicate. I mean, the status the conference or whatever, when we all met, I can't remember what they called it, but that all happened. And I mean, things started to break free. And I mean, it was a little annoying because I'm like, oh my God, this is judicial theater. I mean, this is like, hands waving and all that kind of stuff. But I mean, things at least started moving. And one thing I noticed and I did like was that when I was talking to the local attorney, he was like, okay, in your area, there are 3 judges. Typically you get this one, we don't want this one, I mean, and I know part of it was just to try to make me feel better, but the fact that they knew who we were dealing with and what the different judges, liked and how they normally ruled was helpful. I know we're starting to run out of time, and if you wanted to add something on that, that's fine. But we had one other topic that you wanted to hit. Did you have anything you want to say on what I just said on that, or should we move on?
No, you're right. Move on.
All right. Modification of existing. You wanted to mention that. And I know that that's something that we talked about before. So there's a lot of misnomers on when can I do a modification to modify custody or to try to seek some type of change? Because I've noticed a lot of times people will have an arrangement or something they agree to. Then they're like, oh crap, this sucks. I want to change it. And they get knocked down because they don't ask the question right. So how does modifications work in a custody order or support order and all that stuff?
So modifications have to be in pretty much all jurisdictions because of judicial economy. They don't want to start the case all over from scratch again. So when you're modifying an existing order, it has to be with a material change of circumstances. Some jurisdictions are significant change of circumstances, which is the same. So what you have to prove is that you something has changed other than just your longing for the children. So you would have to show that you have more time, that you've changed jobs, that the children are now older and have different needs. Little Timmy was in baseball before, and now he's decided he wants to be in football, and you're particularly good at that sport. Those sorts of things. You usually can find a change in custody, but if you just go in and say, I deserve more time, you're going to lose because you always deserved more time. And we're running out of time. That's a bigger topic, but yes, you do have to prove a change. And Duane, and also if you're going to have a temporary order, you want to build right into your orders, if you can, that something will be a step-up plan so that you'll get more time later after something is proven or some event happens. That's also a way to get more time without having to go back to court.
I've actually had a few people who said they've done that, where they've had a time schedule, and then, in 2 months, it moves up to an extra day, and then have that written in. I think that's great to have it in there, because the last thing you want is to have to, because if you're dealing with someone unreasonable, they're not going to agree. They're going to force you to go back to court, which is, right, expensive. I mean, I guess if you have tons of money, might as well. I'd rather not do that though.
I think, especially lifer lawyers like I am, we want to work on something that actually matters. So just going back for a couple more hours I don't think lawyers really want to be there. So if you can build it into your previous orders that something's going to increase, I think that's great.
Yeah. It's the so frustrating part about this is stuff like this discussion. People start this process out without knowing. I mean, I didn't know anything. Right. I completely, I was like, never had looked, who looks into family law issues if you're not, in the middle of a divorce, and you're so behind the power curve because you just don't understand the process. And it's so easy to mess up your own argument by saying it the wrong way, or just, that's, I know I'm just kind of talking in circles, but it's just, I'm glad we're having this conversation because I think it's really important. And it's amazing that an hour just flies by. I mean, we barely hit the 3 topics we really wanted to hit. Before we wrap up, is there anything you want to finish off with?
I want to say that people who control their emotions, we talked about that. It's very helpful to stick to the facts. You have to find the facts and then present them. And then you have to organize yourself so that the judge will actually read your facts. And that's enough for today. I'd love to come back sometime if people got any value out of this, Duane.
Looking at the comments, I think everyone has. And before I go, I'm just going to pull up. If you guys want to find out more about Christine, and I'll have links in the show notes and the video description. They have a YouTube page where she's making videos on different topics. So I would encourage you to check that out. And their law firm, she is a practicing attorney, but I just want to say that I appreciate that, you're going the YouTube route and you're trying to provide education that's accessible, obviously to other professionals, but it's out there for anyone. So if somebody is in the midst of this and they want to hear somebody who has, decades of experience, your YouTube channel is great for that. So my computer's locking up here. I'd encourage people to check that out. And then on that, everybody, I appreciate you hanging out with me this morning. Let's do the outro. I hope you enjoyed that conversation. A lot of good information. It's amazing how fast an hour goes. And the last thing I do want to say is thank you so much for the channel members who help keep this going, keep the lights on. I really appreciate it. It helps in ways you guys just don't understand. So thank you so much on that. And I hope you have a great rest of your day. Keep your focus on the kids and work on your documentation. And we'll see you back here tomorrow.